This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to explain why there is no need to plead and prove a fiduciary relationship between an agent and the agent's insured if the insured can prove that the agent must only fulfill the requests made by the insured. Donald Isken sued Galster III Insurance Agency seeking monetary damages for negligence, fraudulent inducement, and fraudulent misrepresentation. Galster Insurance moved to dismiss the complaint because Mr. Isken did not allege Galster Insurance owed him a fiduciary duty. Mr. Isken did not plead fraud with particularity, and Mr. Isken relied on representations outside the four corners of the contract. In Donald Isken v. Galster III Insurance Agency, the Superior Court of Delaware on November 3, 2022, explained the relationship between insured and insurance agent. The facts of the problems and the lawsuit began where Galster Insurance is a third-party broker agency that sells, solicits, and negotiates insurance on behalf of its clients in exchange for compensation. Mr. Isken owned property in Wilmington, Delaware. Nationwide Insurance Company covered the insured premises via a homeowner's policy until September of 2018, when Nationwide elected not to renew the policy. Mr. Isken contacted Galster and instructed its agent broker, Galster III, to obtain new coverage for the insured premises on equivalent terms as the Nationwide policy. Galster Insurance secured a replacement policy through Scottsdale Insurance Company. Nearly 2 years later, 2 storms hit the insured premises. Consequently, the insured premises sustained loss of electricity for several days. Without electricity, the insured's premises sump pump failed and 1 foot of water flooded into 2 fully furnished living spaces in the lower-level living area. All told, the cost of restoring the damaged areas to their previous conditions exceeded $100,000. When Isken informed Galster of the damage, Mr. Galster advised Mr. Isken to immediately file a claim under the replacement policy with Scottsdale. Isken did so. However, through his conversations with the in-house claims adjuster for Scottsdale Insurance Company, Mr. Isken learned that the replacement policy only provided $5,000 worth of coverage for water damage instead of the $50,000 he instructed Galster Insurance to obtain. Galster Insurance argued that Mr. Isken's professional negligence claim must fail because Mr. Isken did not plead and prove Mr. Galster owed him a fiduciary duty. Ordinarily, an insurance agent assumes only those duties normally found in an agency relationship. This includes the obligation to use reasonable care, diligence, and judgment in procuring the insurance requested by the insured. The agent assumed no duty to advise the insured on the specific insurance matters merely because of the agency relationship. A fiduciary relationship is not a required element in every negligence case between an insured and an agent. Generally, an insurance agent does not have a duty to advise a client with respect to appropriate insurance coverage. This general rule, however, does not apply if the agent voluntarily assumes the responsibility for selecting the appropriate coverage, or if the insured makes an ambiguous request for coverage that requires clarification. To the extent that there is any doubt in Delaware jurisprudence, the Delaware court would not and will not require a plaintiff to plead the existence of a fiduciary relationship if an agent allegedly fails to follow the specific instructions of the insured. Mr. Isken has well pled that he explicitly instructed Mr. Galster to replace the nationwide policy with equivalent coverage because Mr. Galster owed Mr. Isken a duty to follow these instructions, even absent a fiduciary relationship between the two. The court refused to dismiss this count of the complaint. Galster Insurance also argued Mr. Isken has not adequately pled the prima facie elements of fraud under Delaware law. The court disagreed. The 3 minimum pleading requirements a fraud claim must meet under Superior Court Rule 9b to survive dismissal must include that the misrepresentations be enumerated, identify the parties to the conversation, and set out the content of the discussions with sufficient particularity to place the party on notice of the precise misconduct with which it is charged. Mr. Isken specifically instructed Mr. Galster to acquire a policy identical to the nationwide policy. The court found the substance of the discussion laid out the elements of fraud with sufficient particularity. Finally, Galster Insurance contended Mr. Isken's fraudulent inducement claim must fail because the claim relies on representations made by Mr. Galster outside the 4 corners of their contract. Isken's reliance on extra-contractual representations, so claims Galster Insurance, ran afoul of this court's, the Delaware court's, bootstrap doctrine. A fraud claim can be based on representations found in a contract. However, where an action is based entirely on a breach of the terms of a contract between the parties and not on a violation of an independent duty imposed by law, a plaintiff must sue in contract and not in tort. A plaintiff cannot bootstrap a claim for a breach of contract into a claim for fraud by alleging that a contracting party never intended to perform its obligations or simply by adding the term fraudulently induced to a complaint. Essentially, a fraud claim alleged contemporaneously with a breach of contract claim may survive, so long as the claim is based on conduct that is separate and distinct from the conduct constituting breach. Isken did not allege Galster Insurance breached their contract. Rather, his claim was rooted in Mr. Galster's breach of duty owed to him in tort alone and independent of their contract. The court therefore refused to dismiss the fraudulent inducement claim under that theory. Sometimes a little knowledge, in my opinion, can get an insurance agent in trouble with the court. When an insurance agent is given a simple and direct instruction to replace one policy with another that provides identical coverage, failure to fulfill the request is a breach of the duty imposed on insurance agency and can result in tort liability for the failure. The negligent failure cost the insured at least $45,000, and by claiming he had replaced the nationwide policy with an identical Scottsdale policy is both negligent and appears to be fraudulent. The trial, if not settled, would appear to be an interesting claim to a jury. This video was adapted from my blog Zelma on Insurance, which is available free to anyone who asks by clicking on the link at zelma.com/blog. You can subscribe to the blog and thereby receive an email every day that a blog is posted, which is usually 5 days a week. You might also find it useful to subscribe to my rumble.com videos and to my youtube.com videos, as well as to my locals community and my Substack publications. Thank you for your attention.